My name is Dennis Jones. I'm a Senior Financial Advisor here at CCA. We're fortunate today to have John de Groot with us. John is a special counsel and lawyer who specialises in the area of estate planning, asset protection. John, welcome.
Good to be here, Dennis.
Thank you for your time today. We're here to have a bit of a chat today about estate planning and the importance of it for all of us, because as far as we know, there's a 100% strike rate. We're all unfortunately going to die at some stage. Our observations as advisors is that some people embrace proactively estate planning and many others do not, and often leave it until the last minute, and often it's done badly. A lot of people avoid it altogether. As a specialist in this area, what's been your observation?
Well, I think you're right. I think that is unfortunate that a lot of people don't give it the attention it deserves. We all live very busy lives, and sometimes people just don't say, or say I'm not planning to die anytime soon, things like that. So I do think people tend to put it off if they think they could or should. Of course, if a close friend passes away or there's an accident in the family that might have resulted in a very serious outcome, they tend to rush to a lawyer then and say, well, that's the warning sign, that's the tap on the shoulder that I need to get my affairs in order. But everybody should do it. It's not a case of waiting for a disaster, as you indicated. Or the last thing you want to be doing is making a will in hospital at the bedside. But unfortunately, we do a fair bit of that work.
Yeah, no, it is amazing, really. I mean, as financial advisors, we help people build wealth to provide for their family and provide for their financial future, and they'll spend a lot of time and effort focusing on getting their investment portfolio right. But when it comes to the succession of their wealth, in many cases it's almost like an afterthought. Is it because people think it's bad luck to...
Well, there could be that in it. I do think a lot of people tend to, I wouldn't say a lot, but a number of people will even tap the table at the end of it and say, well, I've now given you those instructions, touch wood, I hope I don't need this will or these arrangements anytime soon. So I do think there's a bit of superstition there as well. But I think more than anything it's time and priority. People are busy, they're time poor, and they just don't get around to it unless there's a really strong, I think discipline and sense of common sense of doing it. I mentioned when we were talking earlier, I feel myself people who devote the time and energy to estate planning are really expressing love and concern and regard for their family and their friends, because if they really think about it, nobody really wants to leave a mess when they're no longer here. And I think that it is an expression of love and regard that people take the time out of their busy lives to make sure their affairs are in order should there be an untimely passing.
You're obviously an expert in this space. It's really...
I hope I'm reasonably knowledgeable, but thank you.
How long have you specialised as a lawyer in estate planning?
Well, really, pretty much most of my professional career has had a very strong flavour. From my early days in the law, I was always interested in wills and estates and grants of probate, and just it's a very traditional, historical sort of perspective on the law, because estate administration has been with us forever, whereas some of our more recent areas of the law are quite recent. So it always fascinated me, the whole area of wills and estates and estate planning. So yes, all my career, which is many decades.
Well, I see you're also a former chairman of the Queensland Law Society, Succession Law Committee. So just reading your CV, it's obviously something you know a great deal about. With that in mind, and from your perspective as an expert in estate planning and succession, when a client says, well look, I'll just get a will kit, and we'll just put something together ourselves, and then maybe get our accountant or financial planner to check it. I mean, I have a view on that. I think people should get specialist advice. Always, it's always worth paying for good advice. But when people say that sort of thing and take their estate planning in my view, quite flippantly, Do you have a view on that, the risks involved?
Well, I'm a biased source, aren't I? Because I would naturally think that people should have professional assistance, but I don't really think that that's other than sensible advice. We wouldn't normally trust a lot of our issues, whether it's our health. We wouldn't go to somebody who wasn't properly qualified to guide and assist us in our health care. So I think in the same way, the care of our estate and our estate planning sensibly deserves to be entrusted to professional hands, to people who know what they're doing and have done it before and can provide insights. The will kits and so on, they're a very, very one-dimensional solution, and they don't go, in my experience, they don't go into any depth of understanding the client's real needs and issues that can only arise when you actually sit down and talk to them about what their concerns and family situation is, and rogue children or rogue in-laws that are becoming outlaws and those sorts of things. So there's a lot of richness of context and circumstance that only a one-on-one chat with a lawyer can really bring out what needs to be attended to.
We've seen, and certainly from my perspective, over 30 years working as a financial advisor, unfortunately we have seen some disasters with families that have been really stressed unnecessarily by parents not taking care of estate planning proactively, and then the family and the extended family, often not just the children, the adult children, but also maybe their partners, buy into the debate. And we've just seen some absolute disasters in that space, not just with regard to families, but also business succession planning. I mean, as a lawyer, you must see some extraordinary success stories in terms of people getting it right and providing more for their family and avoiding stress and perhaps litigation. But on the flip side, you probably also see some absolute disasters. Any interesting ones you can comment on?
Well, one interesting one just the other day was of a farming family who were asset rich and very, very poor in the financial front, and wisely, however, the husband was insured with trauma insurance and life insurance. He was diagnosed with cancer, which resulted in a payout of 1.2 million for him. Fortunately, it was a success story. Some little while later, he's been given the all clear, one hopes indefinitely. But it was just one of those wonderful provisions where the life cover was there, or the trauma cover was there, and there was a protection. Somebody said to me, you hear very few people complain that they were over-insured if something comes along. There's an unexpected death, or there's a disability, or there's a trauma. So that was a good outcome fairly recently that delighted the family, and that really has put them back where they should be as far as having resources to carry on their pastoral interests and so on. The other one was exactly the opposite, where a young family going gangbusters in business and not a cent of insurance, and he was a builder, and he just dropped over on the just dropped dead, as they say, and he literally did on the building side of one of his two major constructions that were going on. Not a cent of life insurance, widow with 3 small children, and I watched that unfold as it sort of seared me for life, so to speak. It was just a tragedy as you just watched the whole thing unravel on this terrified widow and 3 little kids. It was just, and you know, a life cover of a very modest cost, because everybody thought was well and was healthy and had no problems at all with his health. And so it's just that thoughtlessness that he just didn't think that he would ever pass away.
I guess people are busy, you know, and I guess especially with people in business and professional people, but all of us really are busy, and the issue of estate planning and what would happen if is often an afterthought, because we're all going to live forever, we know that. Just one particular issue with which is often misunderstood, the importance of and it's a bit of a technical question, but a testamentary trust as part of an estate planning program, especially for people with children and with mixed marriages. And we're seeing more of that these days. Apparently around 50% 55% of marriages are successful in terms of their enduring, but the other 45% perhaps are not. And of course, I believe in second marriages, it's something like 60% the divorce rate. So we're now used to mixed families as the norm, really. But the importance of people reviewing their wills and estate planning in that situation, but also considering a testamentary. Would you like to just comment on the importance of a testamentary trust?
Well, testamentary trusts are a wonderful vehicle, and we've been really very conscious of them over the last couple of decades, I expect. They are a great asset protection strategy. They protect
Can you tell us to what they are? I mean, I know what they are, but just for our viewers, can you tell us what they are?
Yes. Well, a trust is really a unique conception for the English legal system. Basically, the concept of a trust is I give you $100,000 and I say, look after this $100,000, and you can decide to give it to one of these three people. You are the trustee. Two or three people I say you can give it to at your discretion are discretionary beneficiaries, and I, as the person who's given you the $100,000, I'm called the settlor. But if it's through my will, then I'm the will maker. So that's the trust. You hold the funds on trust for a group of people in it and have a discretion. So in a bloodline testamentary trust, you would be I'm the father, you're my child, you are the trustee of the funds, and you and your children are the beneficiaries.
So the situation we saw recently, which is very unfortunate, father in his 80s passed on, and he left a multi-million-dollar estate to his daughter, and she was married, she's got a number of children, but she, at the time, she was separated pending divorce. So unfortunately what we've now got is into the settlement with her now
and her resources are
now there's now about $4 million that's being contested in the courts, which, if that money hadn't gone directly to her, if it had gone to a testamentary trust created on the death of her father, then that money may have been protected or would have been protected.
I would say more than likely would absolutely have been protected. To this date, the family court have always respected testamentary trusts and have not sought to raid them or bring them into the pool of resources to be divided up. They do regard the assets in a testamentary trust as a financial resource that's accessible to the child, for example, but that's a huge difference from a financial resource and having a modest effect on the outcome of the property settlement, as against it's in the pot and can be divided up. So that's a very important aspect of estate planning, I think.
And a lot of people, unfortunately, will say, a comprehensive will might cost, $2,000 to $3,000 for including a testamentary trust. So the benefit of good advice for people that may have, significant assets, but even for everyone their assets are significant, so it doesn't matter really. I just think everyone wants to protect, most families want to protect the assets for the benefit of the family. I just wanted to ask you, in the time we have, for people in business and for professional people, we have quite a few business owners here as clients, and also health professionals, medical practitioners and so on. People in that space, from an asset protection point of view, will often have their spouse, who may not be a professional person, owning the family home and so on, and set up their affairs that way, which has been traditionally the way. But you and I were discussing the other day the consequences of that if things go wrong from a family law point of view. Would you just like to comment on that?
Yes, well, the first experience I've had direct knowledge of is the wife just selling the family home without the knowledge of the husband, and
so it was in her name? It
was in her name for asset protection purposes. So I've always recommended that you don't do that, that you put 99% or even 999 thousandths of the interest in the home but preserve something to the husband if the husband is a risk person or vice versa, so that that can never happen. And because nobody will buy 99% of a home, they'll want both sides, both parts of the ownership. So that's one thing that's just very, in my opinion, very important to do.
But from my observation, generally, a medical practitioner, for example, would have their spouse own 100%. But it does make sense, doesn't it, for the professional person to retain the 1%.
It's a protection for them, because you just look. In the case I was telling you about, that gentleman believed he had a good, solid marriage. He came home to a note on the door that said, "Settlement of the house occurred today. Your things are left under the house. Collect them at your wish." And it was just a disaster for him. Now, that could never have happened if he'd kept a 1% interest. And as well as that, though, you do have to be careful about enduring powers of attorney, so that they are quarantined, so they can't be used inappropriately by a spouse. So there's a few little protections around that. But could I also mention another aspect of this, using a spouse as the safe haven, you might see, the asset protection entity. I've struck so many where you look at the wills and they are simple wills. The wife leaves everything to the husband and vice versa. So your asset protection strategy can be instantly undone by the untimely death of your safe haven spouse. So that's an issue. The other issue, just when we're talking about looking more thoughtfully and I think carefully about the real setups and what the real implications are, and not getting a false sense of security, you look at your parents' wills. I had a fellow yesterday, and he's anticipating a very significant inheritance from his parents, and he's a high-risk individual. And I said, "Well, are they leaving it to you outright, or are they leaving it to you in a testamentary trust or through a trust?" And he said, "Oh, as far as I know, they're leaving it to me outright." So I said, "Well, you realise that on their death, you'll have all those resources in your hands, and they're available to creditors if the worst happened." So there's an atmospheric, you might say, that you've got to I think in terms of, to make sure that you've covered the bases as best you can. I mean, that requires the cooperation of the parents, of course.
Well, here's a good point, though, and professional people. And it's really interesting. My observation over 30 years is that people, work hard to create wealth for the benefit of their family and their future, but often, they don't have the same enthusiasm to talk about their estate planning and wills. And one issue in particular I wanted to talk to you about today was not only should our clients, who may be in their 40s, 50s or 60s, look at their own estate planning, but also perhaps have a chat to their parents about their estate planning, because obviously when their parents pass on, generally their assets come to their adult children, perhaps, and the grandchildren. And from my observation, that conversation is a really difficult one between adult children and their parents. Why is that?
Well, I don't think it's always the case. There are some, it's the family dynamic. There are some families where there's absolutely a taboo area to go. So yes, it can be very difficult, and others are quite open. Sadly, I think it's more as you say, that is, it's somewhat of a taboo topic, and yet I know of families where the parents are extremely wealthy. They've hidden their wealth from their children, and of course what's going to happen is that when the parents do leave us, then these children will be responsible for wealth that they have never had any experience with. And I think that's a bit of a shame, because it puts a lot of stress on them and perhaps a lot of uncertainty as to how well they'll handle the situation. So I'm one for at least a reasonable level of openness, but particularly addressing the issue of asset protection when it comes to the parents' wills, because sadly there's great prospect that if the parents haven't thoughtfully done their estate planning, then a high-risk individual, whether their marriage is breaking up or whether they're concerned about creditors, suddenly can be landed with resources that they're going to have to instantly share with a spouse or with creditors. So you do have to be, I think, bold enough to speak to your parents and say, it's important that I have appropriate asset protection strategies, and and have that dialogue. I've mentioned to you before, I had an experience just on Tuesday where there's a very significant inheritance due to a child, and the issue is that Dad is not prepared to go to another lawyer other than the one he's been to for 30 or 40 years, very tight with the dollar, although he's enormously wealthy. So their solution, they suggested to me on Tuesday, was, look, I know it'll be all right if we tell Dad we'll pay for it. Okay. So that's a final solution, you might say. It's just some people who just can't get their parents to seriously look at their affairs and to take that overview of protecting the family properly.
Look, it's a fascinating subject, this one. It's, as far as I know, to the best of my knowledge, and all the research I've done has confirmed we're all going to die at some stage. So this is critical for everybody. Typically, we'll see where parents will have, if mum, if dad was to die, that it'll go to mum and vice versa, and then on to the children. Why is a testamentary trust really, for most people, a critical component? My understanding is a testamentary trust is a trust created by the will that assets can go into to be held on trust for beneficiaries, so they don't then receive them directly. But from your point of view, why is a testamentary trust a critical component for most people?
Well, its value lies on, I think, at least three key counts. The first is that it's protected from creditors. The second is it's pretty much, you could say, protected in the family court because it's a quarantined asset, and to date the family court haven't sought to bring it into the asset pool and divide it up.
Can you give us, forgive me for interjecting there, but could you give us an example to explain why that is so important? Perhaps refer to, you probably have a few case studies, can you refer to one that perhaps didn't have a happy ending where a testamentary trust would have been a benefit?
Oh, look, I mean, I had a case just within the last 10 years where the person was bankrupt. Let's just look at that one to begin with, and his aunt passed away. Had it been in a testamentary trust, he got a $2 million inheritance. His creditors were owed around $1 million, so the first cheque in the estate administration at distribution time was $1 million straight to the creditors. So it does happen. So I've been there when it's happened.
So if the aunt had had a will, which the will on her death would have created, if it had been structured correctly, would have created a testamentary trust, the $2 million would have gone into that testamentary trust for the benefit, for his benefit. Of
the nephew, that's right, and his family, which was always what was planned. I'm sure she did not wish to be discharging his bankruptcy because creditors meant nothing to her. The person who meant something to her was her nephew, and he only got, lucky as it turned out, I suppose, he got half of the inheritance. But if he'd been bankrupted for a greater sum than he was, the whole inheritance would have gone to creditors. So that was one example that I've had direct experience with, and it's always salutary when you see that happen. I mean, bankruptcy, unfortunately, is a growing phenomenon in our society, especially in these tough times. So bankruptcies are up, and you just never know when something will come from left field and cause you serious problems. So you do have to, I think, take precautions. It's a risk minimisation, a testamentary trust. The other issue, of course, is marriage. We've got, I think you were indicating earlier, probably 45%, I think, of marriages are not likely to go the distance. And inevitably out of a marriage breakup comes a property settlement dispute often, but certainly a property settlement. And whatever has come into the hands of the parties is up for grabs, it's up for distribution.
So if you just to put that in the context of a case study, and which one that we had some experience with, so if you had a couple unfortunately going through a divorce, and then say, in this case we'll call her Sue, the wife, she inherited a good deal of money around about the same time. I think they'd been separated for about a year, pending the property settlement, and about that time she inherited a great deal of money. Now it was disputed. Now and I'm not sure what the settlement was because it might actually be still ongoing, But if indeed she hadn't inherited that money directly, if it had gone into testamentary trust for her, to benefit her, then in that event it would not have been included in that debate over the settlement.
I think it's fairly safe to say that it wouldn't have been. It would have been regarded as a financial resource which has some influence on the way that the assets are carved up, but that inheritance would not have been in the pot, so to speak, that the family court looks at and says, well, the resources here of this couple are X, and how are we going to divide up X? X minus the inheritance would have been off to one side and being viewed by the court as, well, that's a financial resource, but it's not up for grabs, so to speak, by the husband.
Yeah, look, it's really interesting how people, unfortunately, good advice generally costs a little more. It's probably worth you're a specialist in the space of estate planning. To me, you can compare it with medical profession, where you have a GP and then you have a medical specialist. At the moment I'm seeing a specialist for some issues with my neck. Now I probably don't want, with all due respect to GPs, I wouldn't want a GP operating on my neck. I probably want a specialist neurosurgeon, you know what I mean?
Yes, I know.
So that analogy, I think, with the law, that's why I believe people should see a specialist like you and your firm for estate planning. John, just talking about testamentary trust, you mentioned that there was a significant third benefit. Can you explore that a bit for us?
Yes, it's something that's been on the landscape revenue-wise since the 70s, and that is there's this very special advantage given to testamentary trusts that other trusts don't enjoy, and that is that you can distribute the income to infant beneficiaries who then are taxed as adults. So that means they have the tax-free threshold of, I think it's close to 19,000 now, and then the normal stepping up of those tax rates. So that, you know, if you've got a few children and you know that the first, well, in round figures you'd say $20,000 is tax-free. I've got one family where there are 8 grandchildren, and my client said he has great joy every year in knowing now how much money flows into the family absolutely tax-free through the testamentary trust that his mother set up.
So this is a really interesting point, because the tax-free threshold for individuals used to be 6,000.
Yes, and it was fairly sweet then, but now it's
18,
very sweet.
It's 18,500 now for each individual, and then with low income rebates it's actually around $20,500 per individual. So if we look at a case study where we've got grandparents that are looking at their estate, if they include a testamentary trust with their will and it's done correctly, then say they had 4 grandchildren, then funds can be left in trust for each grandchild, and the income paid out to them and the first $20,000 per grandchild would be tax-free.
That's right, and it can be applied by the parents for their education, maintenance and advancement in life as the
tertiary education and that type of thing.
And just, yes, there's just so many benefits. So, as I say, I've got any expense has been paid many times over in a number of instances where I've got that happening in families, and it's just a wonderful asset. A testamentary trust is a wonderful asset in a family.
It's an enormous benefit when you think, especially with that leap from $6,000 to around $20,000 tax-free. And I mean, it's a big burden for parents with kids at private schools and then going on to university. We have clients that are earning significant income, and half of it is going to educate their kids. So to get the grandchildren, now that might be a good reason, for example, to have a chat for adults to have a chat to their elderly parents about having another look at their will with the benefit of a testamentary trust to benefit the grandchildren.
Yes, well you add that to that benefit, added to the protection in a family law context, added to the protection in a creditor context. I call the tax benefit the icing on the cake, but they give a very powerful argument in favour of a much more sophisticated look at a will to incorporate a testamentary trust or testamentary trusts within it.
thank you, John. That's probably all the time we have today, John. I'd like to thank you very much for your time.
Pleasure.
And we'll be posting this on our website, so hopefully, and anyone looking for further information can go directly to John's website as well, which we'll attach to this video.
Thanks, Dennis.
Thank you for your time.
Pleasure to be here.